A very good afternoon to all my dear students. On behalf of Institute of Chartered Accountants of India, once again, I welcome each one of you present over here. And as we have already started the Indian Partnership Act last time, children, we will be continuing and completing Chapter 1 of Indian Partnership Act today. So, a very good afternoon, Shweta Sharma, Shruti Pathak, Ruchika, Ashutosh, Ayushi, Baba Saheb, Sunil Sharma. Sunil Sharma also has a query for us. Even though there is a contract among partners, why agreement is mentioned in partnership rather than mentioning contract? Okay, so Sunil Sharma, if you have done Contract Act very carefully, you must have understood that meaning of contract is an agreement enforceable by law. So these terms are interchangeably being used. When we call it an agreement, we are definitely getting it implied by the terminology of contract itself, because the word agreement is basically used in order to clarify that you and me decided to open up a partnership. So we made an agreement. So we are signing a contract. Generally, the contract terminology is used when we are going out with the dealers and we're signing general kind of contracts for the purpose of business. Here we are making an agreement. So you are right by saying that there is a difference. The only difference is this agreement is also enforceable by law. So any agreement which is enforceable by law in turn becomes a contract. But the terminology that we use for Partnership Act is the word agreement. Today we'll also be discussing about the partnership deed. That deed is basically the context of your entire partnership. All right. Lisa Jain, Mehek Swati, Aryan, Ananya Kumari, good afternoon, children. Nikita, Ritu Tiwari, Akshay Kumar, Kavya, Pramod, K, Bharat Chaudhary, Bharat Chaudhary, Purva Joshi. Mehek Roy has another query for us. Please repeat mutual agency, the fifth part of the element. Definitely, we will be discussing about the mutual agency once again today. Kevin is saying, I have revised, so that's great. In descriptive question 1, the reference is given to the case law. All right, Mr. Gopal Mishra, we will definitely take up that descriptive question number 1 as well after the completion of syllabus today. Gopal Mishra, you have to remind me while we'll be proceeding towards the end of this chapter that we have to do this descriptive question as well. Kushal, Manisha, Shri, yes, I can see different new names also today. Niklesh, Himanshu, Anushka, good afternoon, children. All the agreements are contract, but all agreements are not contracts. Okay, Ditya, that is absolutely correct. Once again, the true test of partnership. So what we have discussed, Kavya is asking about the true. Alfie Thangal, good afternoon. Kavya V is asking about the true test of partnership. So what is that we have to see when we talk about the true test of partnership? We have to see, number 1, there was an agreement between the partners. We just had a discussion about the agreement. You and me decided either in oral or in writing that we will be doing partners together for a particular business. Great. But that partnership should always be for a business, and we have decided to share the profits. If Harleen ma'am only eat all the profits and does not give the profits to other partners, can we call it a valid partnership? The answer is no. Sharing of profits have to be done. And the third important test, that is the conclusive evidence, is mutual agency. Many of you are again writing the query for mutual agency. So basically the mutual agency means if A, B and C are partners, they have entered into a partnership agreement, then whatever transactions are being done for the purpose of business by Mr. A, B and C will also be held liable for that particular business transaction. So let's take a very interesting example when we talk about agent. Now, if I have hired Mr. Kushal Jain, okay, I've hired Mr. Kushal Jain to work as an agent for my business. I am Miss Harleen Kaur. I'm a sole proprietor. I'm a cloth merchant. I'm doing the business of sale and purchase of cloth. And I wanted to expand my business in Delhi, and I've hired Mr. Kushal Jain as in my agent. He will be selling cloth in Delhi on my behalf. Does this mean that Mr. Kushal Jain is my partner? Yes or no? Quickly, you all have to answer me. I say I've hired Mr. Kushal Jain as my agent. He'll be doing sale and purchase of cloth on my behalf. We have already understood who is a mercantile agent in sale of goods, and I will be paying him commission for this agency. Excellent, Samina and Kushal Jain. The first one to send the correct answers. Very good. Mehak Roy, I hope you can hear us clearly now. Mr. Chang, good afternoon. Aditi, Sarvesh, Swayam, Madhugonda, Tanmeed, all of you. Welcome, children. Ruchika, prima facie means apparently, that means if we have decided to share the profits, it becomes partnership. But what we have to see in partnership is whether we are holding each other liable as a principal as well as agent also. Sunil Sharma says he's only a salaried employee. No, he's not an employee. I told you I've hired an agent for my business. There is a difference between a salaried employee and an agent who is working and doing business on my behalf. Definitely correct, Shruti Pathak, Darshan, Nitil, Nabin, Surya, Aisha, Kevin, all of you are correct. No, ma'am, he's not your partner. He's only an agent. So why we face this confusion of mutual agency principle is because we tend to confuse him with a normal agent. So मैंने अपने बिजनेस के लिए एजेंट हायर करा जो मेरे बिहाफ पे बिजनेस कर रहा है, उसको मैं कमीशन दे रही हूँ. But Harleen ma'am has entered into partnership with Mr. Nabin and Miss Surya Kumari. We have agreed to share the profits on behalf of each other. All of us will be sharing equal profits. So if there were 9,000 profits and we have decided to share equal, Surya Kumari will get 3,000, Harleen will get 3,000, Nabin will get 3,000. Nabin, go and do some transaction in the market for a purpose of business. The dealer can come and recover the money from me and Surya Kumari as well. Why? Because all the partners are principal and agent of each other. Now in partnership, Surya is acting as an agent. I am acting as an agent of Surya and Nabin. So that is how agency principle runs within partnership itself. So although we understood that as an agent, if you're just paying commission, that does not mean that he's your partner. But when as a partnership, you are acting as a principal as well as agent of each other, that means all of you are liable for. That is why it says that the business carried on by all or any of them means even if any one of them. KD Kamath case, you remember? In KD Kamath and Company, only one person was doing entire business. So Supreme Court, they went to the Supreme Court and they said that ITO has refused to register us as a firm because they're complaining that Mr. KD Kamath is having the entire control and management in his hand. So why are you calling it a partnership firm? It should be a sole proprietor. But Supreme Court said, please see what is the true context behind this organization. Are they holding each other liable for each other? Are they sharing the profits? Is there an agreement? So since all the points of section 6 were clearly mentioned in the form of organization, they could be seen. When you call the prima facie evidence, it was evident from the books of accounts that yes, they were sharing the profits. It was a conclusive evidence that Mr. KD Kamath was holding the other partners liable for his actions. Therefore, it was 100% held that KD Kamath and Company can be registered as a partnership firm. But in the same case, Santi Ranjan Das Gupta, where there were no records, we could not see any profit sharings. There was nothing happening between versus Dasren and Murzamul. जो कंपनी जिसने केस फाइल करा था, जिसके अगेंस्ट संती रंजन दास गुप्ता ने जिसके अगेंस्ट केस फाइल करा था, there is no partnership between them. Why? Because see, tomorrow I came to your shop and I told, let's be partners. After 3 years, you filed a case against me and you said that Harleen ma'am is liable for her business because once upon a time she visited a shop and she said that we are partners. So Supreme Court held that are there any books of accounts which are showing that Harleen is your partner? Were you sharing the profits with her? Have you informed the deputy director about your new partnership? Is your organization registered as a partnership firm? Is there any bank account which you have opened in the name of partnership firm? Answer is no. So just because you entered into an agreement with me for one day or for certain purpose does not hold me as a partner with you. There has to be certain records. There has to be conclusive evidence. You were doing your business. I was never liable for that. But today you're asking me that you're liable just because once I said that I'll be partner with you. That does not hold a partnership valid. For holding the partnership valid, we have to see the 5 basic elements are present, which are given under section 4. Section 6 only clarifies same elements. वही section 4 कर break कर उसने section 6 में बता दिया कि ये जो true test है आपकी agreement होनी चाहिए. संती रंजन दास गुप्ता में वो कह रहे हैं सिर्फ म्यूचुअल एजेंसी नहीं चलेगा. एग्रीमेंट थी, आप पार्टनर्स बने थे, आप प्रॉफिट शेयर करते थे या नहीं, सब कुछ इकट्ठा देखना है, तभी आपको पार्टनर माना जाएगा इन अ फर्म. clear ho gaya? I hope all the doubts are now 100% clear. All those who have sent the correct answer, that is great. Anushka Jaiswal, definitely correct, because you're not sharing the profits, you're only paying him commission. Yes, Ritu Tiwari, there was profit sharing in KD Kama. That's why we held it as a partnership firm. Miss Mahalakshmi, Himanshu, Bhargav, good. It's clear now. That's nice. Mahima Jain, good. In case, Mahima Jain is asking, in case agent, we have an agreement sharing of profits and on behalf of businessman, he's performing on all the transactions. Then if all the elements are present, okay, fine. I have hired Mr. Kushal Jain was the agent whom I've hired. Now I told Kushal that you're really doing very well business. Why don't let's become partners? So Kushal Jain came to my place. We signed an agreement. We made a partnership deed. Now we have decided to share the profits and we are doing the business together. We are investing the capital together. It's a joint property now. Now you can call him my partner. Now whatever we are doing, we are holding each other liable. Even agent is holding me liable, but he's not my partner. Unless and until you don't sign an agreement with me, until and unless there are no sharing of profits, we are not doing the business together, we're not holding each other liable, we cannot call it partnership. Samajh aa gaya. Everyone is now clear with mutual agency. Great. Ritu, Shruti, Samina, Nikita. I love when you say it's crystal clear. Great. Varun, Ankur Verma, Maha, Lakshmi R, Ashutosh. Very good. Well done. चलो आगे चलते हैं फिर हमने differences between partnership and company also we have done. There were no doubts in this. We have to start from partnership versus club. Now, a very interesting question is coming up for all of you. Since from last 2.5 years, we were facing a situation of lockdown and you all have become very health conscious and you were eagerly waiting the moment lockdowns will get open, we'll just go back and join our gym and other clubs. So now one of you, let's say Miss Simran has joined a gym and she's regularly going for her fitness classes. She's studying law also and she's enjoying her CA studies also. And whenever she gets time, she goes and attend her gym also. Now she's going to a club named ABC Club, which she has joined for gymming. Now children, your question is, will Simran become partner in this club? If she has joined any club, can you say that she is a partner in a club? Yes or no? Is she a member of a club or she is a partner in a club? Rishu Tiwari, good afternoon. Thank you, Shruti. Yes, Ms. Lisa Jain, in that Santi Ranjan Das Gupta, we are saying that there were no records and no agreement. That is why we have concluded the same. No, ma'am, she's only a member. Excellent. All those who have said, definitely she will not become a partner. She's simply a member of a club. So now we are going to discuss what is the difference between a partnership firm and a club. So here you are becoming a partner in a firm. If Simran has joined A and B as partner and she is doing business with them and she's sharing the profits, she's holding each other mutually liable, then definitely it will be a partnership firm. But here in a club, if you're simply going to use the gym property, you are only becoming a member. Are you interested in gym's property? Say, for example, the treadmill was not working well. Will Simran go and get it repaired? A cross trainer was not functioning properly. Will she go and take care of that? She will definitely not be interested in the property of the club. Why? Because I'm just a member. I'm not your partner. मैं business थोड़ी ना कर रही हूँ club के साथ. I'm just going for my day-to-day activities. I've paid the membership fees and I'm not here for profits. If club is getting profits of 1 crore, you are only paying the fees of membership. You're not having any share in the profits. However, in partnership, you share the profits also. In partnership, you're interested in the property of the business. If ABC are partners and one of the fan is not working and it is very hot, isn't it your responsibility to get it repaired, or you will, Mr. A will just think that B and C ne lagwaya tha and they will only get it repaired? You're also equally liable, right? You're interested in property of the partnership because it's a joint property. But club, you don't have any joint property with the club. Club's property is different. Your property is different. Will the change in partners affect partnership? Will it make any effect? If ABC were partners, A has left. Now there will be B and C who will be running the firm. or B and C has hired Mr. D. So now there will be B, C, D, and who will be running the firm. So dissolution will happen and new firm will come into existence. But if Simran has left and Kiran has joined the club, will it affect the existence of a club? No, it will not affect. So here change in members may keep coming, members may keep going. कोई आ रहा है नहीं आ रहा है, क्लब को मेंबरशिप में उससे क्लब की एग्जिस्टेंस में कोई फर्क नहीं पड़ेगा. But partnership is a kind of organization which is made up of partners themselves. If partners are not there, firm will get dissolved. Clear? So these 4 points of differences between partnership and club, you all have to remember and learn it. And definitely if examiner asks you, you can give the example the way I've shared the example with you. Now let's talk the partnership versus co-ownership. So if we take an example that, okay, you enjoy when I take your names. So whose name will now come? Lisa Jain and Himanshu Bhargav. So Lisa Jain and Himanshu have taken up a property in London. Lisa and Himanshu has taken a property in London. Wow, I'm sending them abroad also. So they have a huge property in London and they thought, let's invest in this property, and they become the co-owners of this property. And now whatever rental incomes are coming, they're sharing between each other. And they said that we will be sharing 50% each of the rental income. Can we call Lisa and Himanshu partners? The answer is no. Ma'am, they're only known as co-owners because they have become co-owners by an agreement. They have signed an agreement. Lisa also signed, Himanshu also signed. All right, fine, we are holding this property together. Whatever rentals will come, 50% you will get, 50% I will get. Now, whatever income is coming and they're sharing that income. This is purely a case of co-ownership. Co का मतलब दो लोग. Own कर रहे हैं means अपना रहे हैं किसी चीज को, ownership ले रहे हैं. So अगर आप मिलकर किसी चीज की ownership ले रहे हो, that is known as co-ownership. That does not mean partnership firm. Why? Because is there any agency principle? Is Himanshu liable for whatever business Lisa is doing? No. Is Lisa liable for whatever Himanshu is doing? Himanshu might be doing a different business. Lisa might be doing a different business. But for the property that they're owning jointly, they're not doing any business. They have just invested in the property and they have made an agreement. Are they having any share of profits and losses? No, they are not sharing any profit and losses. They're only sharing the revenue which is coming as a rental income. Can you transfer your ownership? Can Lisa transfer her 50% interest? Yes, without consent of Himanshu, she can still transfer her interest to anyone else also. But if Lisa is partner with Himanshu, then she cannot transfer her interest unless and until the other partners also give their consent. So if A, B, C are partners in a firm, A will not transfer his share to any other partner unless and until B and C says yes to it. But if A, B and C are co-owners, co means two or more than two together ownership, having a together ownership. So if A, B, C are co-owners of any property, A can transfer his share of property to Mr. D or anybody else. He does not need to ask Mr. B and C. Now Mr. B and C will share the rentals with Mr. D. Clear ho gaya? Here implied agency is definitely under partnership. You have the principle of implied agency. We are holding each other liable. There is mutual agency. And here the contract may be expressed or implied. See, here he's using the word contract because it is enforceable by law. This agreement is also definitely enforceable by law. But this agreement is only for the co-ownership. Here the partnership firm, you're forming a contract, you're forming an agreement which is legally binding and you are liable to share the profits. You are having mutual agency and you can transfer your share only with the consent, means only with the permission of other partners. Clear ho gaya? Partnership and association of person. This is something which we have discussed last time also when I told you that 3-4 people have come together and they want to hold a program for Diwali or maybe it's January, so Lodi is coming up. So you decided that we'll be holding a Lodi function for our society. Everybody is going to contribute 500 rupees each and you bought nice bonfire and you bought nice peanuts and sweet dishes and there is nice gajar ka halwa that you have got prepared for all the society members. Now what are you doing? You are asking everyone to contribute this 500 rupees and you're holding an event of Lodi and you're doing certain kind of partnership with each other because they're contributing the money. Will you call it a partnership firm? Is there any intention to enter into business? No, there was no intention to do business. It was only collective effort being made by everyone to come together for a charitable or religious or a social purpose. Yahan we are doing it for a social entertainment purposes. So all these kind of activities where you're associating people, they're coming together, they're holding an event, they're contributing money. Even if surplus is left, they're dividing it among each other. If they have gained any profits, still they divide it among each other. Then also it will be known as association of person. Why, ma'am? Because there was no intention to do business. We are not saying that we will be doing a business on regular terms. We are only holding a particular event together. We are not holding each other mutually liable for our actions. We are not doing any kind of profits which we have to share further. So if anyone asks you why partnership is different from association of person, in partnership you have business, association of person you have no business. In partnership you enter it for the profits. Here you're not earning any profits. In partnership you have mutual agency. In association of person you have no mutual agency. You're only doing it for the religious or charitable purposes. Clear? And the last one is partnership versus joint Hindu undivided family. So Hindu undivided family means the family which is staying together since long years. They have not been divided and they're doing any kind of business. Now, whatever business HUF is doing, they're also known as joint Hindu family or Hindu undivided family, one and the same thing. Whatever business HUF is doing, there is a senior member of the family who is known as Karta, and the other co-partners, other members are known as co-partners. Whatever business is being done by the firm, by the business, by the family, they divide the profits equally and they're just doing a business as a part of family members. In partnership, you become a partner by signing an agreement, by having a partnership deed. However, a right in the family is given by status, means by creation of birth. If Mr. A is born in HUF family, then he becomes the member of HUF by birth. Not that he has to sign an agreement. Will you ask Mr. A, the newborn baby, to sign an agreement to become a member? No. Or will you ask him to become a minor, then only you become a member? No. A minor becomes the member immediately on birth in case of HUF. However, in partnership, minor can be admitted for the benefits of partnership only if all the other partners are agreeing. So if there is a partnership firm ABC Associates and Mr. A had a son, Mr. D, will he automatically become a partner in the firm? It says no. Even if he's a minor, he can be admitted only if B and C are consenting or saying yes, or even if he have become major and partner, say Mr. A has died and now they want to sign a partnership with his son, Mr. D. So he still needs to sign an agreement. He will not just become it's not an ancestral business that father has died, now son will join. But in HUF, it is an ancestral business. Even if father has died or the son has born or the grandparents are still no longer there and the family is still growing, whatever family members are coming, they are all considered as the part of the family business. They do not need to sign any kind of agreement. So there can be n number of members, unlimited members in HUF. You can either have 5 members who are joint family business or there are 50 members, whatsoever is the number, there is unlimited. There is no limit given to HUF membership. However, in partnership, we learned the number of members should not exceed 50. And where is this 50 mentioned? This limit is given under Company Rules 2014. Number of members cannot exceed 50 in case of partnership. However, HUF does not have any limit on the number of members. And liability of partners is unlimited. You have to pay whatever is the liability of business. You cannot say that my personal assets will not be held liable. Even your personal assets, each and every liability of the business has to be paid off even from your personal assets. But in HUF, you cannot call all the family members to pay off the liabilities. It is only Karta who is the head of the family, whose liability is unlimited. He has to bear all the liabilities. However, the liability of other members is limited to their share in the business. Clear, okay? You can go through the other points of HUF and partnership given in a study material. They have given a very elaborative examples and differences. So good, you can read them as well. In case you have any doubt, you can ask for that. Mr. Ankur Verma, no, in gym you cannot become a partner because you're only joining the gym as a member. Ritu Tiwari, that's correct. Lisa Jan is saying, thank you for sending me abroad. So you were not in abroad. The property that you were holding was in abroad. So it's not necessary that you will go abroad and hold it. All right, good. I'm glad you're enjoying it. Okay, HUF, Ritu Tiwari, I hope HUF is now clear to you. Meaning of inheritance, Sunil Sharma. Inheritance means, so you're asking here, by co-ownership. So either you join by an agreement or inherited. So if you're inherited your dad's property. So there was Mr. Rex whose dad has died, and now automatically the property will be inherited by Mr. Rex because he's the son. So you get your ancestral properties. So co-ownership can either by an agreement we can sign with each other, or two brothers who was son of Mr. X. Mr. X has died. Now the property will be co-owned by the two brothers. Yes, Mahima Jain, that she will also become part of Hindu undivided family after marriage. 12 members. Yes, Swati Giri, whatever the members in HUF, unlimited membership is allowed. Yes, Akshita, if you start doing partnership in that same co-ownership property, it will be set to forming a partnership. No, Yashraj, company rules and acts are different. When we go to Companies Act, we learn it about there at that time. Okay. Meaning of inheritance is now clear. I hope, Sunil Sharma, you have understood. Okay, so how many questions we have done last time, children? I think we just did the first and the second one, calling for accounts and closure point. Mr. Naveen, just tell me which point are you asking? When we go to the study material, you can raise this query that time. Okay. The true test for partnership was also done. Have we done this one? A, B, C are three partners. I don't think we have done this one. Okay, now children, you have to let me test your knowledge where you're thinking caps, and the third question comes in front of you on the screen. A, B, C are three partners. A has purchased the furniture for the purpose of business from Mr. D. Can D recover the money from Mr. B and C as well? If yes, why? If no, why? Read the question carefully and answer me. Question number 3. Yes, Mr. Aryan Kumar, whatever latest amendments have been given, we will be considering that for the meanwhile. So 100 is the upper limit which has been given by Companies Act. So as of now, the rules have amended it to 50. So they have restricted the maximum cap limit of 50. So although till 100, you can go not beyond 100, but if you are following the rules, you will write that 50 is the number. Okay, Pramod, Samina, Akshita, Aryan, Mahavir, Shruti, all of you are correct. Ritu Tiwari, Vadekar, Baba Saheb, Aisha, Himanshu, Kushal. Gopal Mishra is the only one who has given me the correct answer with reason also. Yes, because of mutual agency. Very good. Bharat Chaudhary is also writing the same. Mrs. Latha is very good. Yes, ma'am, because it is for business purpose. Excellent. Krishna, Aman, Mehak Roy, Kevin, Pramod K, Ayushi. Good, all of you. Tina Verma, Aisha, Akshita, Shrikantya, your answer is correct. Siddhartha, Anushka, Madhu Gonda, Satvik, your answer is correct. If all the parties have agreed, no, you don't have to say if all the parties have agreed. Even if the parties are not agreeing, it is implied agency. Relationship of mutual agency has to be applied. We are assuming that B and C also were aware that Mr. A is doing this purchase of furniture. Anything that you have purchased for the purpose of business, other partners will definitely be held liable for that. This is implied in the partnership deed. Okay. Darshan Sharma, correct. Nitil Soni, correct. Shweta Sharma, correct. All of you are correct, children. So yes was the correct answer to this one, and the reason was because of mutual agency relationship. Okay, this fourth one is also very interesting. Which of the following is not the essential element of partnership? Agreement between partners, sharing of profit between all the partners. The business must be started within 6 months from the date of agreement. Business must be carried on by all or any one of them acting for all. So which one of this is not an essential element? Okay, Nidhi, Nabin, Punjabi Asif, Aditi and Mukesh Yadav, your answer was also correct. Mr. Suchang, Narendra, good. Okay, all of you have sent the correct answer. Answer number 4, it is part C. That is, the business must be starting within 6 months. No, ma'am, you did not taught us any such essential element. This is no essential element, and there is nothing written like this under Indian Partnership Act. The only thing we have to see agreement, sharing of profits and mutual agency, and all these 3 points are given under section 6, which makes it clear that only if you have these 3 points, then that form of organization is known as a partnership. In the absence of agreement to the contrary, the partners are not entitled to share the profits. They will share the profits in the capital ratio. They will share the profits equally, or none of the above. So wear your thinking caps and answer me, what will happen in the absence of the agreement to the contrary? Also, you should know the meaning of this thing. Absence of agreement means if we have not decided about this context, if we have not made sure how the profits will be shared. To the contrary means to the context of this topic, then how the sharing of profits will happen. All right, now one won't be taking names because so many of you are there in the class today. So it's very difficult to take names of all the students. I will only tell the correct answer. So fifth का कौन सा correct answer है? A, B, C and D. All of you, most of you, 90% of you have given correct answer. 2-3 students have written D. I don't know why. C is the correct answer. If there is nothing mentioned in the agreement, then all the partners will always share the profits equally. You must have studied about this in accounts as well. So if there is a profits of 10,000 and there are 2 partners A and B, we have not decided, then 5,000 will be given to all the partners. You will not simply go to the capital ratio or any ratio of your choice if it is not written in the agreement. But children, if it is written in the agreement that it will be 2:1 or it will be 3:4, then definitely you have to share the profits in the ratio which is agreed. Okay, now this one is also very interesting. The position of minor is same in the partnership as well as in the HUF. Is it correct, true or false? So HUF and partnership have the same position of the minor, true or false? Okay, Mr. Ankit Jha has a query for us. Meanwhile, I'll read the query. If one of the partner purchases furniture for business purpose, even if partners does not agree on it earlier, then will the other partners be liable? So section 19 to 26, when we discuss about in detail about the rights and liabilities of partnership, Ankit, there your question will get answered. Consent of other partners is definitely implied when you sign the agreement. But if some condition was imposed, Mr. A is not allowed only to go and do the purchases. Then if he is doing the purchases or if he is eating the personal profits, all these points, ifs and buts will be covered in relationship of partners. So section 19 to 26 will cover this specific question and you'll understand it there better way. As of now, simply remember, if you're not saying any additional conditions are not being assumed, we are simply understanding that in a partnership, you do anything, I will be liable. I do anything, you will also be liable because of the relationship of mutual agency. Yes, Mrs. Aisha, that was correct. Aisha Tasneem. No, Narendra, it was not B, it was C for the fifth one. Simran says false, Niklesh says true, Sarvesh says false, somebody saying false, somebody saying true. Why are you getting confused? Mr. Himanshu Bhargav is saying if there was no agreement, then how will they do the business? So it is simply saying, children, this question is simply saying in the absence of agreement to the contrary means if I have not written in the partnership deed about what ratio of sharing the profits. तो हमने सारी agreement sign कर ली, but उस agreement में हमने sharing of profits के बारे में नहीं बताया. Then the sharing of profits will be done equally. Okay, it's not that we have not signed an agreement only. In the agreement, we have not mentioned about the sharing of profits. Okay, Himanshu? Okay, the correct answer, children, so many of you are saying wrong answers also. So true was the position of minor is same in partnership as well as in HUF. True was the wrong answer. So the correct answer for question number 6 is false. Why false? Because in HUF, you become a member by birth. However, in partnership, you have to sign an agreement in order to become a member, and you can only be admitted for the benefits of partnership. Here, we don't hire you just because for the benefits or losses. You are member in the business, family business by birth only. Very good, Sunil, Nikita, Aisha Sood, all those who have given the elaborative answers. Also, Nabeen, Aman, Aditi Roy, Shruti Pathak, great. Kavya, Madhu Gonda, all of you are correct, children. All right, children, now let's proceed and start with another new topic. These MCQs basically help to brush up your skills. You become more, the picture gets more clearer in your mind when you do and discuss MCQs, the shorter parts. Okay. Now let's start with another topic, that is kinds of partnership. So what are the types of partnership that we can have? What are the kinds of different partnership? Depends upon the duration. Children, means time period. Duration means depending upon the time period that we have decided, or depending upon the extent of business. What type of business we are going to do will decide about our type of partnership that we're going to have with each other. So first, let us understand on the basis of time period, there are two types of partnership. One is partnership at will, and the second is partnership for a fixed period. So if you'll read in study material, it says the partnership where the period duration has been clearly determined, that partnership is known as partnership for a fixed period. If A, B, and C decided today, that is 6 January 23, they decided that, okay, fine, we are going to be partners for next 4 years. A, B, and C on 6 January 23 decided to be partners for 4 years. So 24, 25, 26, 27. So on 6th January 27, the partnership, children, will come to an end. Yes or no? If we have decided, you, me, and the third party, that we will be partners for 4 years. So after 4 years, 6 January 2027, the partnership will come to an end. This kind of partnership is known as partnership for a fixed period. That is, means we have decided for how long we will be doing the partnership. But if A, B, and C decided today on 6 January that we will be doing partnership with each other, but they have not determined the time period, but they have not fixed the period, they've remained quiet for how long we have to do the partnership, that kind of partnership is known as partnership at will. Partnership at will means partnership at your own choice. If you liked each other, you may continue to be partners for 20 years. And if you did not like each other, you might continue the partnership till today evening. So the partnership which continues without deciding any fixed period, we may wind up the partnership tomorrow itself, or we may wind up for next 20 years, we might be partners. We have not decided for how long we're going to be partners. That kind of partnership is known as partnership at will. That means the period you can write down where we have not decided about the where we have not decided about the period for how long the partnership will continue. The period for how long the partnership will continue is known as partnership at will. And the partnership where we have decided the time period for how long the partnership will continue, that is known as partnership for a fixed period. So clear ho gaya on the basis of time duration. If we have not decided the time period, it is partnership at will. If we have decided the time period, it is partnership for fixed period. The partnership for fixed period will come to an end on the expiry of that period. Partnership at will come to an end whenever the partners want. You can write this line also. Partnership for fixed period will come to an end on the expiry of the fixed period. That is, in our example, it was 6 January 2027. So if we have entered the partnership for 4 years, so after the expiry of 4 years, that is 6 Jan 2027, the partnership for fixed period will come to an end. However, partnership at will will come to an end only when the partners decide. So whenever the partners will say that we now want to close the firm, they can close the firm. If they're not liking each other, they might just do the partnership for 1 or 2 days. Or if they are having such a nice bond, they might continue the partnership for 10 years or for 2-3 decades. But it all depends upon their own choice. Now, I have a very interesting question for all of you. If on 6 January 2027, which was a partnership for fixed period, A, B, and C thought that 4 years we have been doing such a nice business, and now since it was partnership for a fixed period, it will come to an end on 6 January 2027. But still, A, B, and C wanted to continue the partnership. So this continued the partnership after 6 Jan 2027 also, without deciding for how long. वो कहते हैं हमें एक दूसरे के साथ मिलकर इतना अच्छा लगा है, हम इतना अच्छा बिजनेस कर रहे हैं कि अब ना हम और पार्टनरशिप इसको कंटिन्यू करते हैं और टाइम पीरियड डिसाइड नहीं करा. For English students, they decided to continue the partnership further without determining the time period. In that case, the partnership for a fixed period will now get converted into partnership at will. Yes, correct answer. So now this partnership will become partnership at will. So where you have not decided the time period, that is partnership at will. Where time period is decided, that is partnership for a fixed period. Another interesting thing, third type of partnership, that is particular partnership. Particular partnership means the partnership which we do to do a particular event. So A, B, C were partners in the cloth business, and A, B, C decided that let's hold an exhibition in Delhi and let's do the partnership for holding out this exhibition, that is 1-day event. So there was a 1-day exhibition to be held in Delhi, and A, B, and C came into partnership for that particular event. Now, when they came into partnership, they invested equal amounts and they shared the profits out of that particular business. And they were very satisfied and happy with the particular partnership that they have signed. And now that after it was for 1 day, if the event was for 1 day, that particular event. So now this particular event comes to an end. So the particular partnership also comes to an end on the expiry of that particular event. But again, A, B, and C were so happy working together that they said, let's continue partnership with each other without deciding the time period. Then this particular partnership also gets converted into partnership at will. So number one, what is particular partnership? On the basis of business. Extent means duration of business. Here it is duration of time. Here we are talking about for how long you're doing the business. If it is for a particular event, for any single day event, or maybe for a particular purpose that you have decided to do the partnership, then it is particular partnership. Otherwise, A, B, and C are running the business and they have decided for a term or they have not decided for a term. That is just simply known as the general partnership. अभी general partnership के ऊपर बाद में आएंगे, पहले particular partnership की conversion समझ लेते हैं. So particular partnership, we decided to hold an event in Delhi and that event ended. Particular partnership will come to an end. All our rights and liabilities were restricted to that particular event which we were holding in Delhi. A, B, and C have nothing to do what they are doing at their home, what business are they running. They were only coming together for this particular Delhi event partnership. We have contributed a capital for that event. We have shared the profits. Khatam ho gaya. But now we liked each other so much that we want to do business more and we decided to continue our partnership without fixing the time period. Then children, what will you call this particular partnership has now become? If on the expiry of that particular event, the particular partnership has come to an end and we still want to continue as partners without deciding the time period, then it will become what? Krishna, Purva, Sunil, Suchang, all of you are correct. Nitin, Shruti, Mahima, Tanmeet, excellent. It will now become partnership at will. So once we have decided that we want to do the partnership only till this period, that is particular partnership. We have decided the time period, that is partnership for fixed period. Where we have not decided the time period, where we are not particular about the business that we want to do, then it becomes partnership at will. Very good. Simran, Siddharth, Nidhi, Alfitangal, Sarthak, Samina, Shruti, Ankit Jha, all of you are correct. It will get converted into partnership at will. 3 type की partnerships clear हो गई. What is this 4th general partnership? This general partnership is very interesting and at time it bothers you a lot कि ये है क्या? वो तो तीनों की definition समझ आ जाती है, but इसका समझ नहीं आता ये रहता क्या. So I have another category for all of you. It says on the basis of liability of partners, partnership is further divided into particular partnership. ध्यान से सुनना है अभी. Particular partnership is not just on the basis of extent of business, it is on the basis of liability as well. Particular partnership, general partnership. And what is the third category, children? Can you think about the third category on the basis of liability? Let me test your knowledge. I haven't told you before, but do you know it or not? What can be the third category of partnership? Yes, Mr. Yashraj, they can definitely make a new agreement, but if they have not fixed the time period, then it is partnership at will. Yes, children, what will you call this kind of partnership? Third category, anyone knows? On the basis of liability, we have general partnership, particular partnership. So particular partnership mein our liability is restricted to that particular event. General partnership mein, which you all have done, all the elements of the partnership are present and the liability of the partners is unlimited liability. That means if the assets are not sufficient, the partners will be personally also held liable. Particular partnership में unlimited थोड़ी ना थी. Particular partnership में liability limited to the particular event. Only for that exhibition event, our liability is limited only to that particular event. General partnership means normal partnership which we have agreed, unlimited liability. And what is the third category of partnership on the basis of liability? Wow, great. Aditi says partnership for specific period. No, ऐसी कोई partnership नहीं है. Limited liability, I guess, Mr. Nabeen, your guess was good. Mr. Raman says active partner. That is a type of partner. I'm asking type of partnership. Krishna is right. Nikita, Madhugonda, Mahima, Sichang, Shriyas, Swatigiri, Sarthik, Kevin, Mahavir, Simran, correct. Krishna, Mahima, Aryan, Siddharth, all of you are correct, children. Great. So the third category is limited liability partnership. All those who are saying specific category, there is no specific category of partnership. The third category is LLP, which is a very important unit in itself. After completing partnership, children, you'll be studying about LLP also. LLP means limited liability partnership. This is the only partnership where the liability of members is limited. Why do we open LLP? earlier we had 5 different forms of organization: a sole proprietor, an individual who is doing the business. I thought I want to expand my business. I joined hand with my employee, or maybe I've hired someone as a partner. We formed partnership form of organization. We wanted to do a business on a very large scale. We thought, let's form a company only. First, we formed a private limited company. Then we thought of expanding it more business, investing more, asking the public to subscribe. So we decided to open a public company. Nowadays, a single man can also run a company. He is known as one-person company. So there was certain thing that the government thought that it is very simple to form a partnership. अभी हमने जब सेशन शुरू ही करा था तो यू वाज आस्किंग मी, मैम एग्रीमेंट क्या होता है? तो मैंने आपको बताया कि अगर आपने पार्टनरशिप करनी है तो आप सुबह उठे, आपने फ्रेंड को कॉल करा, एग्रीमेंट साइन करी और पार्टनरशिप हो गई. बड़ा सिंपल काम है. वी डोंट हैव टू, इट इज नॉट कंपल्सरी टू गेट इट सेल्फ रजिस्टर्ड. वी डोंट गेट एनी कॉर्पोरेट काइंड ऑफ लीगल एग्जिस्टेंस. We're only individuals who are doing partnership. So tomorrow, Sunil Sharma and Akshita thought that we want to be partners. Akshita and Sunil signed an agreement. They decided about the sharing of profits. They decided what they are doing. Name of partners was mentioned in the partnership deed. They invested the capital and they said that we are mutually liable for each other. Partnerships were set to form. But the only major drawback of this partnership is unlimited liability. Tomorrow, if the assets of the business are not sufficient, Sunil and Akshita will have to bring their personal assets also from the home in order to pay the liabilities of the business. This is what is the meaning of unlimited liability. So government thought, let's make this partnership little more flexible. Let's do something that you are partners also and your liability also gets limited. Therefore, this new concept of LLP was introduced recently, in which you have the flexibility of partnership. That means agreement, you simply sign and you become partners, and your liability is limited. Plus, you get a corporate legal existence. It is a kind of a company that you're forming. It is not actually a company, it is partnership only, but you get the legal existence and your structure is like as if a company has been formed. ज्यादा डिटेल में नहीं जाएंगे एलएलपी के. एलएलपी जब आप पढ़ेंगे तो आप समझ लेंगे. For now, for my information that you have to remember is why we get confused with general partnership. So general partnership is nothing. It is only normal partnership which has unlimited liability. Why we are telling you? Because now LLP has also come up. There your liability is limited. General partnership mein liability is unlimited, and particular partnership mein liability is limited to the extent of that particular event. क्लियर हो गया. टाइम पीरियड के बेस पे 2 हैं. पार्टनरशिप एट विल, नो टाइम पीरियड डिसाइडेड. पार्टनरशिप फॉर फिक्स्ड पीरियड, टाइम इज फिक्स्ड. Particular partnership and general partnership depends upon your nature of business. You have just joined hands for doing a regular business. It's a general partnership. It can be partnership at will or fixed period. You have decided to do the partnership for a particular event, then that partnership is only for a particular period. That is known as particular partnership. And LLP is the partnership where you don't have any unlimited liability. Your liability is limited to the extent of the business that you're doing with the other partners. Clear? So a partnership at will is one which does not have a partnership deed, which does not provide for how long the business will continue, which can never be dissolved, or which does not have any partner. Tell me, answer me this. Yes, Punjabi Asif, it is also known as unlimited liability partnership. That is also correct. But general partnership का मतलब ही है कि unlimited liability. Yes, Mr. Suchang, the personal assets of the partners are also held liable because your liability is unlimited. Shweta Sharma, 7C is absolutely incorrect answer. B is the correct answer. Simran says 7A incorrect. Why are you saying incorrect answers, children? 7B is the correct answer. Varun, Purva, Pramod, Sunil, Krishna, Nikita, Samina, Ritu, all of you have given the correct answer. Partnership at will means, I just now told you, where you have not decided for how long the business will continue. Time period is not decided. That is known as partnership at will. Other points are just to confuse you. Does not have a deed. I never mentioned any partnership is that well where you don't have any partnership deed. You can have the partnership deed in oral or writing. That is your choice. Which cannot be dissolved. This was never taught to you. I told you time period is not fixed. Whenever we want, you have written that line also. Whenever the partners decide, they can dissolve it. And if you want to continue it for long, they can continue it. Time period is not decided. That is the only case of partnership at will. A partnership formed for carrying out particular venture or undertaking is known as limited partnership, joint venture, a special partnership, or a particular partnership. Think and answer. What will you call this kind of partnership? Question number 8. Yes, Kushal, your answer was also correct. All of you have given the correct answer for the previous one. Time was not fixed. That's correct. I'm waiting for the 8th answer. 8th answer is also correct. Many of you have given. Let everyone do it. Krishna, it's wrong. Kushal Jain, venture means any kind of particular business that you're doing together. So particular partnership is the correct answer for this one. Great children. All of you have almost given the correct answer apart from 2 and 3 who got confused with joint venture. So joint venture was intentionally written over here to confuse you, and those who got confused, great. So the correct answer is particular partnership. There is no partnership where I told you it's a venture partnership. If you are just doing a business or a particular venture means for a particular kind of business or event, we are having a partnership we are forming. I just told you the example of exhibition event that we were holding in Delhi. Then that kind of partnership is known as particular partnership. So 8D is the correct answer. Now this you all again know. Partnership formed without any fixed period or duration is called unlimited partnership. Is it called co-ownership? Is it called partnership at will, or it is known as particular partnership? What kind of partnership is that? Ankit Jha, when you do LLP, you will get absolutely, definitely a good clarity about how the liability gets limited. So you will understand this point in that chapter. So 9C is the correct answer. Well done, all of you. We just discussed right now only that if no time period is fixed, it is known as partnership at will. Now let's take a small break. It's already 3 o'clock and let's take a small break and then we'll complete the chapter today itself. All right. Thank you. All right, welcome back, students. So let's go to the study material once and just cover the chapter that we have just discussed, the topic. So these are all the points of differences. HUF, those who were asking where the points are mentioned. Here are the points which are given under your differences between HUF. They're all very simple points. You can just go through them. And now they have also given the definition for co-ownership. Anybody who is holding, people who are holding the property jointly or in common is known as co-ownership. Here, partnership at will under section 7 has been clearly defined. No period has been fixed and no determination of partnership is done. These conditions are very important to be satisfied in order to call as partnership at will. Children, many a time examiner can give you a descriptive case study based question also. You simply have to see if time period is not fixed, determination of partnership is not done. It is partnership at will. All right. So we have discussed all these points from here. Now we come to the partnership deed. Partnership deed simply is the result of an agreement. Basically, the agreement that we make between partners is known as partnership deed. I told you any partnership which is formed, it is formed by an agreement. The agreement may be oral or in writing. And why, children, we need the partnership in writing? I taught you in the last time also class that if in order to settle any disputes which happen between the partners, it is always preferable to have the agreement in writing. So if they were partners PQR and they have decided to share the profits equally in the ratio of 1:1, but what happened? P was taking all the profits home and he was not giving any share of profits to Mr. Q and R. In that very case, Mr. Q and R thought that we will go to the court and we'll drag Mr. P to the court and we'll fight for this thing. But they remembered that they have made the partnership agreement in oral. There was nothing in writing to prove that the partnership was to be shared between three of them in 1:1. So they had a lot of trouble in proving this point. So law says in order to avoid any kind of disputes, means in order to avoid any kind of problems. Now Mr. P was suffering, but he was not able to take an action because there was no written evidence. It was very difficult to prove it in the court of law. So that's why it is preferable that the partnership agreement should be in writing. So everything is written in the records. So tomorrow when you become chartered accountants and you enter into partnership, always make sure that you sign a written agreement so that all the facts and all the rights and liabilities are clearly mentioned over there. So that document which contain all the terms of partnership, how the profits are to be shared, how will you become the partners, who is bringing in how much capital, how the business will be done, what kind of business that you're doing, all these things are mentioned in the document. This document, which is signed by all the partners, is known as partnership deed. Partnership deed must be duly stamped as per the Indian Stamp Act. So stamp paper पे proper आपका थप्पा लगेगा and sign होएगा by all the partners in order to make clear that partnership is now formed between all of you. All right. So I think my voice is audible. There was some network error in between. Yeah. So if all the terms which has been defined in this document is known as partnership deed, and we have to get it signed and stamped on the Indian stamp paper, and you get it signed by all the partners. So children, it's not simply that you just sign it on a piece of paper. You have to get the stamp paper in order to signing. Yes, we have signed the partnership, holding each other liable for our actions. So this kind of agreement, this document is known as partnership deed. So what are the clauses which are contained in partnership deed? Now, it's not very complicated. You don't have to go to the company's website or get it registered, or you don't have to make the pains of filing a lot of documents. It is only a deed that you have signed between each other. What all clauses have to be included? Obviously, you should know the name of the parties. If there are 3 parties, mention their name. If there are 5 parties, mention all of their names. All right. So maximum number of partners, minimum, we have already discussed. They should not exceed more than that. Nature of business. What kind of business are we doing? Are we into electronics business? Are we into cloth merchants? What kind of business we do should be mentioned in the partnership deed as well. Duration of partnership. What is the time period? So if we have mentioned the time period, it's a fixed partnership. If we have not mentioned the time period, it is partnership at will. So whether we mention the time period or we don't mention the time period, the characteristics of the type of partnership will be depending upon the time period that we have decided. Name of the firm, whether the name of firm is ABC and Company or it is ABC and Associates, whatever name you have chosen, it should be given in the partnership deed as well. What is the meaning of capital? So A, B, and C have decided to do the business. A bought 10,000 from home, B bought 15,000 from home, and C bought 20,000 from home. All these things that they have invested in the business is known as the capital that they have invested in the business. Share of partners in the profit sharing ratio. What profits they are going to share. So whether I mentioned here, it was asking, somebody was asking me, na ma'am, ki clause कौन से क्लॉज में यहाँ पे लिखा होता है आपके पार्टनरशिप डीड में कि शेयर ऑफ प्रॉफिट्स कितना है. अब अगर हमने यहाँ नहीं लिखा शेयर ऑफ प्रॉफिट्स, देन ऑब्वियसली इट विल बी डिवाइडेड इक्वली. Otherwise, whatever share that we have decided in the partnership agreement, whatever ratio we have decided, the profits will be shared in that ratio only. Banking, which banks are we going to have account? Will we choosing Yes Bank or we choosing Axis Bank? With which bank we're going to have the accounts of the firm, the books of accounts of the firm, how the firm will get its name opened with the bank. All these details will be mentioned in the partnership deed. And this is the capital of whatever the amount that the partners are bringing in order to start the business is known as the capital brought in by the partners. You must have read in accounts that you get IOC, that is interest on capital, interest on drawing. So this is the capital which is invested by the partners, and they're also paid the interest on this capital invested. Again, only if all the partners have agreed, then only the interest is paid. Other and remaining 5 things are powers of the partners. Now, what all powers are we giving to them? Are we giving the power to all the partners to go and have the client meetings? Or are we defining only the limited partners can go and have the meeting? What all authorities and powers are given to the partners should also be clearly stated and mentioned in the agreement over here. Retirement and expulsion of partners, very important point. How the partners are going to retire. If somebody is leaving the organization, he is saying goodbye, his age has retired, because of his age he is retiring, or his terms and conditions are not good with other partners, that's why he's leaving the firm. All these details about the retirement as well as expulsion of partners should be clearly mentioned in the partnership deed. Retirement, you all understand the meaning of retirement, somebody who is leaving the firm. A, B, C are 3 partners. A is leaving the firm. How he can leave the firm, whether he has taken the consent of other partners, all this procedure is mentioned that partners can retire from the firm. What is the meaning of expulsion of partners? Expulsion means to throw out someone from the firm. It's a very harsh word used. It's a very kind of term which is used only if it is mentioned in the agreement that you can expel a partner. Number 1, then only you can expel a partner. And it is not very simple to just throw out someone from the firm. Throwing out means I'm using a very rude word. That means now you will not do partnership with us. Something has happened with which a partner is not now eligible to continue. Maybe he has cheated. Maybe he has done some kind of fraud. Maybe some sexual harassment case is going on against that partner. So you can expel the partner. If such kind of wrong, illegal activity is being done by any of the partner, then he can even be expelled from the partnership. But how the expulsion has to happen, how the retirement has to happen, it should be mentioned in this clause should be mentioned in the partnership deed. In chapter number 2, relationship of partners, we will discuss in detail about the expulsion and retirement of partners. On death of partners, whether the firm will get dissolved, will continue. Again, this thing also should be mentioned in the partnership deed. Dissolution of firm, chapter number 3, we will understand how the firm gets dissolved, how the partnership gets dissolved. All these points are also part of your partnership agreement. Provision for salary or commission, if any, payable to partners. So children, partners get the share of profits. Do you think partners also get salary or remuneration? Remember in your profit and loss account, when you used to write to managerial remuneration for partners, Sometimes we are paying salary to one of the partners. For example, there are 3 partners, A, B, and C, and Mr. A is very good in handling the accounts, and we have made Mr. A as the manager also of our business. So now you give salary to Mr. A as a manager, whatever position he is holding, he's also getting salary in addition to his share of profit. So then you also give certain kind of commissions or salaries in addition to the partners, what they're getting as a share of profits because of the role that we have assigned to them. In that cases, whatever salary and commission is to be given, it should also be clearly mentioned in your partnership deed. Samajh aa gaya? So partnership deed is nothing. It is only simply an agreement that we are signing. And if such a kind of question come in the exam, you have to write in detail, these are the clauses of partnership deed. Now, the amazing fact is many a times, not just once, many a time examiner has given you 4 marks straight away question from Indian Partnership Act, that is define partnership deed. अब उसमें आपने सिंपली इसकी डेफिनेशन लिखनी है, एग्जांपल देना है, एंड ऑल दीज क्लॉजेस, one line for each clause you should write it down and mention it in order to score full 4 marks. And generally what the students will do, students will think partnership deed it is simply agreement, इसको क्या पढ़ना है, हमने ये छोटा सा पैराग्राफ दिया हुआ है स्टडी में, so we can simply skip it and we can go ahead, and examiner gives you a question on the basis of that small paragraph only. So nothing you have to leave from the study material. Each and every topic has to be covered from the study as well as from the presentation and notes that I'm sharing with you. Now we will be covering the last topic of this chapter, that is types of partners. There are 7 different types of partners that are discussed in this chapter. One by one, we will be taking up all these types of partners. Now, this slide I somehow find very interesting, and it is found very enjoyable by the students also. Now, why a cartoon picture has been inserted over here, I told you earlier also, when we are discussing case laws or when we are doing such kind of sleepy topics where you yourself fall asleep because there is so much theory coming up. So it's very important to stay attentive also. And when you see the pictures, the things become more clear. Visual representation is always more keen to our eyes, more pleasing also to see it also, and it helps you to remember also. So here, children, you can simply see with the picture that they have shown that this Mr. Specky, who is clearly holding the stick in his hand, the presentations, the graphs he's discussing. He's so much engrossed in the business of the firm. He's so much actively understanding and participating. And this lady is also so carefully listening and paying attention what all is happening, why our sales are going up or down, or whatever is the picture of organization that they're discussing. They are actively engaged in the business. And what is this Mr. C doing over here? So this is Mr. A and this is Miss B. What is Mr. C doing? He's sleeping like you people. Huh? It's afternoon time and he's falling asleep and he's least interested. What is happening in the business, what presentation A is giving, what Miss B comments she is passing. He has nothing to do. So what will you call this Mr. C? What type of partner? With the picture it makes you clear, huh? Thank you so much, Mr. Sunil Sharma, for such a nice appreciation and words shared by you. Thank you. I hope, Simran, the voice is now clear. Nikita, in general partnership, you simply have to remember on the basis of liability, the concept of liability that I taught you. General partnership, unlimited liability, LLP may limited, and particular partnership is only for the particular business that we have discussed in detail. Here, selfie tangle stamp paper price will also need to be paid for the signing the partnership deed. All right. So are you telling me what kind of partner he is? Yes, Himanshu is sending a laughing smiley also with the sleeping partner. Madhu Gonda, thank you so much. I'm glad you're enjoying the class. He's a sleeping partner. B looks also about to sleep, then Meet is saying. Yeah, but she'll not sleep because by luck she's active partner. So C is a sleeping partner. Very interesting. So अब सबको समझ आ गया sleeping partner का क्या काम होता है? सिर्फ सोना है और हमने business में कोई interest नहीं लेना है. But is it the only thing that we have to remember and recall in sleeping an active partner? Is it that simple? Let us see from the study material also. Does the study also takes the active partner and sleeping partner in such a simple way? So it says active partner, the way he was representing, the way he was actively involved, it clearly makes the picture clear who has become the partner by an agreement. Yes, definitely has signed an agreement, and he is actively participating in the conduct of the business. So in general, children, when I give you examples, ABC are partners, all these ABC are known as active partner, जो कि partners business कर रहे हैं. So whenever we sign any partnership, the partners are generally the active partners only. So active कह लो या actual कह लो या ostensible partner. Many times you have trouble with this word also. Ostensible basically means to show off. Ostensible means to show off. Now you have bought your new Levi's pair of jeans and you really want to, show off in your front of your friends. And maybe say, for example, if a girl has got long nails and she has got the nails extension and she's just getting the pictures clicked like this or something, just to do a show off, just to highlight it. Similarly, they have resembled this active partner, the way he was holding the stick, he was showing the presentation, कि वो बड़ा show off कर रहा है, means ostensible है, हर जगह अपनी presence दिखा रहा है, activeness दिखा रहा है. So an active partner is also known as ostensible partner. Why? Because he is trying to show off by his presence, because he is actively engaged in the business. He's always coming in front and dealing with the clients. He's always concerned about the profits of the business. He's always looking in for the new ventures, how we can expand our business, how we can do it more in a more way. All these kind of qualities are given to the active and ostensible and actual partner. So ostensible partner is one who is the real partner, one who is exceeding in the business what they are doing. Right. So he is acting as an agent of other partners. Yes, ma'am, because mutual agency relationship is always present and he is doing the ordinary course of business. In the event of his retirement, very important point over here, he must give a public notice in order to absolve himself of liabilities. Now, this Mr. A, an active partner, was so actively involved. He was doing the business. And today, if Mr. A is leaving the firm on 6 January 2023, this Mr. A decided to leave the firm. Now, there are other partners, B, C, and D, who still continue. So, B, C, and D will be left, children. There was a supplier, Mr. E, who has supplied the goods to them in the month of December. And his payment was still pending. Now, Mr. A, an active partner, ostensible था, बड़ा show off करता था. E को तो A के बारे में बहुत अच्छे से याद था because he was an active partner. He was always doing show off. He was always engaged, actively present. And this Mr. E, on 8th of January 2023, went to Mr. A and said, please pay my 10,000 rupees for the purchases made in December. Now, children, if payment was pending or maybe some transaction was done on 8th January itself, let's not confuse with December, फिर वो गलत हो जाएगा. A transaction was done with Mr. E on 8th January. He has already retired on 6th Jan. And Mr. E went to Mr. A for the payment of 10,000 because he remembered and recalled Mr. A as an active partner. So do you think A is liable to pay E? Yes or no? Absolve means, Mr. Kevin, this is what we are understanding. Absolve means to remove himself from all the liabilities, to make himself free from all these liabilities. So what will happen? Is Mr. A liable to pay Mr. E for 10,000 rupees? Yes or no? What do you think? Yes, Mr. Ankur Verma, your excellent answer that you have given. Sleeping is not participating, but we will come to sleeping partner, but let us first complete the active partner. Miss Molly Prabhakar, all the PPTs have already been uploaded on the portal. For the partnership, for the sale of goods, it's already done. For the partnership, also you can download it tonight. Kushal Jain says, yes, ma'am. Sayukta also says, yes, ma'am, he will be held liable. Others are saying, no, ma'am, he's already retired. So now what the confusion is, on 6th of January 2023, Mr. A has retired. Transaction was done after this date on 8th of January. All those who said, no, ma'am, is absolutely correct. Yes, because, ma'am, he has retired, so he should not be liable. But there is one point that I forgot to tell you about a public notice. The meaning of public notice means to announce it in the public that, look, I am now retiring. Mr. A failed to give this public notice. Law says if you have not given this public notice, now Mr. E can still recover this money from you because he will assume that you are still a partner with ABCD Associates. Since you have not given the public notice, you will be held liable. Therefore, it says in order to absolve yourself means in order to free yourself from all these liabilities, whatever acts are done after his retirement, in order to make yourself free from it, you must give a public notice. So लिख लो, active partner must give a public notice. Active partner must give a public notice in order to make himself, in order to make himself free from all the liabilities incurred by the firm after his retirement. Clear ho gaya? So active partner is joining by an agreement. He's sharing the profits. He's doing the business. He's holding the partners liable for his action. All the ingredients and elements of partnership are present. Yes, you're an active partner and your liability is unlimited. All the partners have unlimited liability. That all my students know by now. All right. And he's the only kind of important adjective that we have used with the active partner is he's an ostensible partner, means he is actively engaged in the conduct of the partnership. And second thing we have learned, he should give a public notice whenever he is retiring. Otherwise, Mr. E, the third party, will come and hold him and make him liable. So if you don't want to be liable after retirement, don't forget to give your public notice. Now comes your interesting sleeping or dominant partner. Sleeping partner को dominant partner भी कहा जाता है. What is the meaning of dominant? Means closed. Say for example, your bank account, if you have not made it operational and there is no balance for many years, it is just lying and it becomes dominant, means now it is sleeping. It is not working. So dominant means something which is not actually working. So a partner is known as dominant on sleeping when he is not actively participating in the conduct of business. Like in a picture, he was sleeping. He had nothing to do with what the other partners are doing. उसको कोई लेना देना नहीं है. Business अच्छा चल रहा है, बढ़िया चल रहा है. कोई ostensibility नहीं है उसमें. Show off करना नहीं आता उसको. He is just a partner by an agreement. He is sharing the profits. Yes, ma'am, he is sharing the profits. He is liable to third parties. Definitely, he is liable to third parties, and he is not even required to give the public notice. Why sleeping partner is not required to give the public notice? Tell me. Let me see whether you are all my active students or sleeping students. Why do you think sleeping partner is not required to give a public notice? All those who have given the answer for the earlier one was correct. It's difficult to take your names now. Now you tell me the answer. Why sleeping partner is not required to give the public notice? No one knows him. Gopal Mishra, excellent. Because the partner is sleeping, Kushal Jain says, because he is not known to the public as a partner is the correct answer, children. Even if he does not give a public notice, nobody know him as a public in the public that he was a partner because he was sleeping partner. He was never going to the business meetings. He was never interested in the expansion of business. He was not actively engaged in the participation of business. Therefore, he is not required to give a public notice. So simple difference between active and sleeping partner. Active partner will give a public notice. Sleeping partner is not required to give a public notice. Active partner actively engaged in the business, sleeping partner is not engaged in the business. ये दो point of differences आपने याद रख लेने in the active and sleeping partner. But does sleeping partner become by an agreement? Yes. Number 2 point, he is not actively participating. Number 3 point, he is sharing the profits and losses, whatever ratio they have decided. Sleeping partner will also get the profits. How interesting now? He's not even doing any business and still he's getting the profits. Why? Because he has invested also, right? And he is liable to the third parties. Yes, he is liable to the third parties. Sleeping partner without doing any business also holds unlimited liability. His liability will still remain unlimited for all the acts of the firm. So business active partner kar raha hai and liability sleeping partner ki bhi. And the 5th point is he is not required to give any public notice. ये सारे 5 points today you will make the notes, you will write the points, and in your law notebook that I have asked you to make a separate law notebook, write out these points so that you learn it today itself. Okay. Again, I'm telling you, it becomes very easy when you're discussing it with the teacher. Teacher is talking, you are listening, you're understanding. I want it to remain easy even when the classes are over. So write it down today in points for yourself, active and sleeping partner. Clear ho gaya? Let's go to the third category of partner, nominal partner. Nominal partner में मेरा favorite example आता है when we take the name of any actor, maybe a Shah Rukh Khan, I have been taking the name, or any other actor, whatever of your choice you can imagine, a person who is just lending his name. So ABC Associates were doing electronics business, and they thought that this one of the heroes, he's really doing well. He has given good sponsorship for electronic items. Why don't we ask him to lend his name to us in the business as well? So one of the celebrities who has lent his name to the firm, but he does not have any real interest in it. So ABC Associates went to Shah Rukh Khan and they said, Shah Rukh Khan, can you please give your name to us, to the firm, so that because when people will hear Shah Rukh Khan is a partner in this firm, they will start investing, they will do more business dealings, and we'll have more clientage and we'll earn more profits. So now this kind of partner who is just lending his name to the firm and has no real interest, Shah Rukh Khan ko koi lena dena nahi hai aapka business acha jaye ya bada jaye, but he's simply lending his name to your firm, then such a partner is known as nominal partner. He's not a real partner, he simply lends his name to the firm and he has no real interest. It is known as nominal partner. You will not even give him any share of profits. He's neither investing in your firm nor he's taking part in the conduct, but he will have unlimited liability. Why do you think a nominal partner will have unlimited liability? Because the liability the firm is incurring is because of his name. So if a nominal partner is a partner who has lent his name, he will not eat the profits, he will have no participation in the business, he is not investing money, he has no real interest in the firm, nor does he take part in the conduct of business, but his liability is unlimited. Why? Because it is because of his name that you're getting the business. And now tomorrow, if you're not able to pay the money, this Mr. Shah Rukh Khan will also be held liable in order to pay to the outsiders. So nominal partner का simple ये जो chart study material में दिया हुआ है, all these nice 5 boxes you have to learn. Number 1 point, partner is lending his name. Yes, ma'am, he's a partner who is lending his name without any interest. I'm not having any interest. If I lend my name and I actively participate also, then I become active partner. If I'm just lending my name and I have no interest in the business, I'm not even sharing the profits. You had 10,000 profits per day because of my name. You're earning in crores, but I'm not taking any share of profits. I'm a nominal partner. I'm not even participating in the conduct of the business. The only important point is nominal partner is still held liable to third parties for all the acts of the firm. Sounds strange, but yes, it will happen. Why? Because business is also coming because of his name. तो तभी तो वो सेलिब्रिटी है ना, क्योंकि वो लाइबिलिटी पे ऑफ कर सकता है, उसको प्रॉफिट्स में कोई मतलब नहीं है. ही इज आल्सो गेटिंग मोर ब्रांड नेम, मोर publicity is happening by lending his name to the firm. So it is because of his name that you're getting the business. So whatever liabilities are incurred by the firm, nominal partner will also be held liable to the other parties. Partner in profits only. Now this fourth category of partner is very, very amazing. He just wants to eat the profits. He has no interest in your losses. So there were 3 partners, A, B, and C, who were doing the business, and they were active partners. They were actively engaged in the business, sharing the profits, doing everything. One day, Mr. D came to them and he said, I also want to become a partner with you. So Harleen ma'am has already taught us that if you want to be a partner, please sign us an agreement with us. So Mr. D signed an agreement. And in that agreement, Mr. D said, I want to be partner in profits only. So Mr. D really have a goodwill in the market and he was really doing well. And ABC thought, okay, we will also he's also kind of a nominal partner having a good reputation. Let's allow him to be a partner for profits only. Because of his name also, we'll get good profits. So Mr. D signed an agreement that I will be a partner who will only be sharing the profits and I will not be liable for any losses. Tomorrow, if the firm has any losses, I will not bear those losses. Such a partner who is appointed or who is signing an agreement only for the profits is known as partner in profits only. So what will this partner do? Number one, he will only eat the profits. Number two, he will not share the losses. Number three, his liability is limited to the acts of the profits only. So if I have three customers with whom I'm dealing, and two of my customers are very profitable and third is always making me suffer losses, then this partner in profit only is liable only for these profitable activities only. So whatever acts of the profits are done by the firm, for that he holds his liability to third parties. But for any losses if the firm is incurring, partner in profits, Mr. D in our case, will not be held liable. So tomorrow if the firm had profits of rupees 10,000, so all these four will eat the profits equally. 2,500 A ko milega, 2,500 B ko milega, 2,500 C ko milega, and 2,500 rupees D ko milega. But if the firm had loss of rupees 9,000, then A, B, and C will equally share at 3,000, 3,000, 3,000. D will not share any kind of losses. And liability to third parties, he will be liable only for this profitable act of 10,000, whatever transactions needs to be paid to the third parties. Mr. D is liable. He is not liable for any losses of the firm. Now, who are the incoming partners and who are the outgoing partners? Again, very, very simple. Any partner who is joining the firm with the consent of other partners. Now, this admission of a partner is another interesting topic which we do when we go to chapter 2 also. Here we are simply understanding what do you call a person who is joining the firm. Number one, a person who is admitted as a partner means he is joining as a partner into number two, an already existing firm. Number three, with the consent of all the partners. Then such partner is known as incoming partner. And point number four, he is not liable for any acts done before his admission as a partner in the firm. Now let's understand incoming partner with the help of an example. ABC Associates Children is a firm, and on 6th Jan 2023, Mr. D joins our firm. Now, if A said, I don't want Mr. D to join, and B and C are happy that Mr. D is joining, can Mr. D join the firm? Yes or no? I said, A said, I don't like Mr. D, I don't want him to join, but B and C are happy with Mr. D joining as a partner. Can D join as a partner? Yes or no? Yes, Mr. Suchang, that is correct. Similar one as nominal, that is good. Okay, Pramod K, that is also good. Ritu Tiwari, anyone would like to nominate? I told you because you're building a brand name for yourself also when you become a nominal partner. Miss Simran is asking what is the answer for the third MCQ. So when we go to the presentation, you can ask me then. Miss Shweta Sharma, he's not contributing in any losses. So he's not even getting the profits. When we talk about the nominal partner, he's only held liable to the third parties. Why he would agree? Because he's building a brand name for itself as well. Excellent, Gopal Mishra. Minor is the person who is joining for partners in profit only. Great. Thank you, Punjabi SF. I'm glad you're finding the explanation of the chapter easy. Thank you so much. Who is a sub-partner? Miss Samran? Hold on. Relationship of partners में हम sub-partner में जाएंगे. अभी नहीं समझेंगे. No, ma'am. D cannot join. Excellent. All those who have said no, ma'am, he cannot. Mahavir, very good. He says no because consent of all the partners is required. Great. Tanmeet says majority wins. No, I never said majority. I said consent of all the partners. So you have to read law very carefully. Mr. D cannot join the firm because all the partners have not agreed is the correct answer. Yes, Mr. Yashraj, they will be working as brand ambassador. That's correct. Correct. Ashutosh says if all the partners consent, then only he can join. That is also correct. So now you all have understood first point that all the partners have to give their consent. They have to agree. Then only Mr. D can join. So now let's assume in this example that A also agreed that, okay, Mr. D, you can join the firm. So A, B, and C, all the partners, not majority than me. Okay, all the partners have to agree. So if all the partners have agreed, now Mr. D can join. Yes, ma'am. Now Mr. D can join as a partner. So Mr. D joined as a partner on 6th January 2023. This Mr. E, who was a supplier and he was very happily dealing with Mr. A, an active partner, has made a supply to the firm for 20,000 rupees, and he wants to recover his 20,000 rupees now. So now again on the same date, 8 January 2023, this Mr. E came to recover the money for the goods supplied in the month of December. In December, E has supplied the goods, 20,000 payment was to be recovered. Will D also be liable to pay for this 20,000 rupees? Do you think D can also E can recover the money from D also? Can Mr. E recover the money from Mr. D for the goods supplied in the month of December? Yes, ma'am, or no, ma'am? And why, ma'am? Kushal and Krishna says no, ma'am. But why, ma'am, is not given. Akshay Kumar, you can write the answers in line. It means depending upon the case study. If you're getting a descriptive case study, then your answer has to be framed long. These such kind of questions that I'm asking, it's absolutely fine if you're answering in one line. No, ma'am, he cannot recover. Why? Gufran, you are saying yes, that's not correct. No is the correct answer. Most of you have said no, that's correct answer. He's not liable to pay. Why? Because active partner is not liable for any acts done before his admission. So like retiring partner is not liable after retirement, provided he has given the public notice. Similarly, a new partner is not liable for any acts of the firm done before his admission. So if before 6 January any activities were done, Mr. D will not be held liable because वो तो आया ही firm में 6 January को है, तो why he will pay for your December liabilities? Clear? Similarly, a retiring partner, I told you if Mr. A is retiring and he has given a public notice, then he will not be held liable for any acts done after his retirement. Outgoing partner means a partner who leaves the firm in which rest of the other partners continue to carry on the business is called retiring or outgoing partner. So somebody is leaving the firm, somebody is saying tata bye-bye to the firm, that means he is retiring partner. Such a partner remain liable to third parties for all the acts of the firm until public notice is given. So number 1 point, partner who leaves the firm, others are carrying on the business, this is known as outgoing partner. Point number 3, his liability is unlimited. Point number 4, only till the time of public notice. Once he has given the public notice, then he will not be liable. All right. So children, let's take 2 minutes break over here because next topic is very important and I want to finish it today itself. So let's take a 2 minutes break and then we will complete. Meanwhile, you just read the types of partners. All right, students, welcome back once again. And I've just gone through your queries also. Somebody's asking in law, the answers quantity or quality matters. So definitely your quality of the answers matters. Even if the quantity is less, it's absolutely fine. So here are the notes that you will go through for the types of partners. And now the last type of partner that we have to do today before winding up. Let's complete that. Thank you so much, Ayushi Bothra. I'm glad you are enjoying the class. Okay, Gopal Mishra is reminding us for that case study question. So after this partner by holding out, we will go and we will do that. Mr. Ankur Verma, again, outgoing partner and incoming partner. In both the cases, we have to get the consent of all the partners. No partner can ask you that you will not leave the organization. There has to be certain specific reason. In that very case, when we go to retirement of partner, we will understand in detail over there. All right. Now, let's come to section number 28. When itself, again, a descriptive case study question can come from this topic, that is partner by holding out. Now, this is very, very interesting concept, children. Remember, by estoppel, I told you how the sale is being made by a seller by estoppel, by saying that, yes, I'm a friend of mine said that I am a seller and he sold the goods and then he was held liable. Similarly, if you're not a partner in the firm and you simply say you're a friend of one of the partners and you simply told the client or the third party supplier that, yes, I'm the partner, then tomorrow you cannot deny from that fact. Remember the meaning of estoppel, that once we have said, we cannot deny. एक सलमान खान का कोई डायलॉग भी है मूवी से रिलेटेड ना, जब मैंने कुछ ऐसे कुछ करके है कि जब मैंने किसी एक बार मैंने जो हाँ कर दी फिर मैं किसी के नहीं सुनता. तो इसी तरह से स्टॉपल में एक बार जो आपने हाँ कर दी कि yes I'm a partner, then you cannot deny from that fact. You will remain a partner for that third party and you will be held liable for the actions of the firm as well. Now let us understand point to point how this person by estoppel becomes a partner in a firm. Number one, when a person represents himself or knowingly permits himself. Number one, you are representing yourself. So Mr. A was one of the friends of PQR. PQR were the partners and Mr. A is a friend of Mr. P. He knowingly represents himself. He says that, yes, I am also a partner in the firm. Or he allows, knowingly permits himself. P is saying that, look, Mr. A is also partner. He remains quiet. He says, yes, I am also a partner. या तो खुद बोलकर कि हाँ मैं पार्टनर हूं, या फिर किसी को अलाउ कर. दोनों तरीके से क्या कर रहा है? टू बी रिप्रेजेंटेड एज अ पार्टनर इन द फर्म, when in fact he is not. He is allowing the other partners, or he is himself admitting as a partner that I'm a partner. In reality, point number three, he is not a partner. Point number 4, then he becomes liable like a partner in the firm. Once you have said you are a partner, you become liable like a partner in the firm. Point number 5, to whom are you liable? You are liable to anyone who has done transaction with the business of the firm because of this representation. So any party who gives loan or who gives supply goods to the firm because of this reason that you are a partner, you have said that then you become partner by holding out, you become partner by estoppel, and the third party can also hold you liable for this kind of thing. Understood? So let us do the example which is given in the study material. Here we come to an end of our presentation and we still have to do one example which we will complete. So this is the very, very interesting, and somehow I have an intuition that this kind of example can come as a descriptive case study in exam also. And if it comes, it's a lottery for you because you simply have to answer the way it has answered over here. X and Y are partners in the firm. X introduced A, a manager, as his partner. So बच्चे पहले मुझे ये बताओ कि A partner था? No ma'am, A तो manager था. X and Y partners थे और A उनकी firm का manager था. But X ने third party Mr. Z. Who is Mr. Z? Mr. Z is a third party. He's a client. He introduced A as a partner. A remained silent. अब एक बार जो आप silent रह गए, that means you have allowed yourself to be introduced as a partner. So this third party Z, believing that A is a partner, he gave 100 TV sets to the firm on credit. He was so impressed with the way A was dealing, and he thought that A has a good knowledge about the business. I will give you 100 TV sets on credit because A is also a partner with you. X, Y, and A are partners, and he was very happy with the dealing. The A was managing the whole transactions and client meetings, so he supplied 100 TV sets. Now, after the expiry of credit period, he gave him 3 months credit period. 3 months have expired. Z ko paisa nahi mila. Z did not get the TV payment sets. He filed a case against X and A. उसने कहा ए तब तो बड़ा हीरो बनकर आया था मेरी शॉप में और मैंने उसे टीवी भी सप्लाई कर दिया, एक्स को भी और ए को भी, और एक्स ने कहा था ये मेरा पार्टनर है. सो ही फाइल्ड एन एक्शन अगेंस्ट एक्स एंड ए फॉर रिकवरी ऑफ हिज प्राइज मनी. So children, do you think A has become partner by estoppel in this case? Yes, ma'am. Number 1, A becomes partner by estoppel under section 28. Will A be held liable for the recovery of money? Yes, A, the manager, will also be liable for the prize money. Why? Because he has become partner by holding out. Section 28 of the Indian Partnership Act 1932 has become applicable. Because he remained silent, he has allowed himself to be a partner. And once you have allowed yourself to be a partner, you will become liable like a partner in the firm. To whom? To anyone on this faith who has given the credit to the firm. So Mr. Z has given the credit to the firm because you were the partner, assuming you were the partner. Therefore, Z can hold you liable, and Mr. A will also be held liable in this case. समझ आ गया? It sounds difficult, but it's very, very simple and it's very, very interesting. The only thing is in exam, how you have to represent the answer to such questions. So if examiner give you such questions, you will write 3 paragraphs. Number 1 paragraph, provision of the law. Section 28 याद आता है, ठीक है, नहीं याद रहता. As per the provisions of Indian Partnership Act, this is the in whole story that you have to write, that a person who represents himself, knowingly permits, represented as a partner in the firm, he becomes liable to anyone who on the faith of such representation has given credit to the firm. So पहला paragraph आप पूरा ये लिख कर आओगे कि this is what is actually the meaning of section 28. Paragraph number 2, you will write the facts of the case. What are the facts of the case? That Mr. X, a partner, has introduced his manager, Mr. A, as a partner. He was actually not a partner in the firm. And Z has done the transaction with the business transaction on the basis of this faith that A is a partner. Clear facts of the case. Conclusion. Now, since Z has trusted Mr. A to be a partner and Mr. A has allowed himself, represented himself in such a way as if he's a partner in the firm, therefore, A, the manager, becomes liable for the prize money because he becomes partner by holding out. Section 28 of the Indian Partnership Act. Khatam. The way you write the answer is very, very important. If you'll simply write one line, children, yes, A is liable. I don't know why he's liable. Then I don't know why will you be getting the marks as well. Okay. So I'm here for 1 more minute. If you have any queries, you can ask me. Your descriptive case studies still left. I'll just take that as well. You're asking in page number 2.30. So I think you were asking about the sale of goods, child. So sale of goods. Okay, children, you have class on Sunday with me for unpaid seller. So I have noted down this question number 1, page number 2.30, Mr. Gopal Mishra. So I'm just writing it down, and in the next class we will take up this question because this is again from sale of goods. In partnership, if you have any questions, page number 2.30, first question, I have written down this one. If in partnership you have, you can ask me. From which chapters the case studies come, Mr. Nabeen? There is no as such rule that from which chapter the case studies have to be coming. They can come from any chapters, and after partnership also we will do the mock test papers as we have done in sale of goods. Thank you, Ritu Tiwari, for all the appreciation. Yes, commitment dialogue, Mr. Bharat. So always remember this commitment dialogue when you discuss about estoppel and holding out. Ankur Verma, that's correct. Acknowledgement and stop from denying, that is also correct, Mr. Gopal. All of you have written that dialogue. Great, Aditi, Nidhi, Akshay Kumar, good. A will be held liable. That was good. Interesting topic. Thank you, Madhugonda. I'm glad you find it interesting. Thank you, Shweta Sharma. Burden of proof. Mr. Ankit Jha, the burden of proof will definitely lie on the party who is claiming that A was a partner. So Z has to prove in the court that this all transaction happened and we have given the supply on the basis of this faith. Nominal partner को consideration में Miss Lisa Jain, once you're acting as a nominal partner, you're simply lending your name. It is only on the basis of your goodwill that the firm will be getting the business and you're held liable. It depends upon the agreement that they have made with the nominal partner about what kind of share he will be getting in return. Subject to the provisions of this act and any other law for the time being in force, Mr. Ankit Jha, this line means that whatever is written in the act after this will become applicable, but subject to the provisions. Why he is using this specific line in case of transfer of title? Because we have already done that condition as to title where a non-owner cannot sell the goods. If you're not the owner, breach of condition happens and the buyer can the true owner can recover the goods from the buyer and buyer can file a case for recovery of prize money. However, subject to that condition. So here when he's saying subject to the provisions, he's talking about that apart from this condition, when condition as to title and warranty as to undisturbed possession, we are not talking about these points. Apart from these points, these are the few cases where we can transfer the title by non-owners. Okay. Thank you, Nidhi Yadav. Illustrative versus exhaustive. So illustrative means something, Sunil Sharma, where you're just giving the examples, and exhaustive means the whole length where you have to take it in consideration. Yes, Ankur Verma, you must make your notes as well. Thank you, Himanshu Bhargav. Thank you so much. Thank you, Kushal. Thank you, Alfie Thangal. I hope I can't see any more queries. Elements of partnership 5 point, please. Mehak Roy, we just did that 5th point, mutual agency, in the beginning of the class also. So you go back to the recorded lecture and listen to it once again. Thank you, Suchang. Thank you, Swati Giri. Glad that you're falling in love with law. That is good. Joint stock company, Tanmeet. Again, it is the terminology used for a company. All right, children, all the topics are crystal clear. Kushal Jain has written that as well. Mahima Jain, Pramod K, Sunil. Thank you so much, children. Thank you. And Miss Priyanka, thank you so much. So see you all on Sunday now. We will be completing the topic of unpaid sellers, and then Monday, Wednesday, Friday, we will be completing your partnership for the chapters. Thank you so much. Goodbye.